Today we will talk on conflict of interest. Particularly we are talking about procurement of works in which contracts are awarded to a third party. So we will be talking on conflict of interest in relation to consultants, contractors and the departmental employees or staff. When we say conflict of interest, it means that a person having outside interest that clashes with the interest of his or her job, business or organization. It may be in the government or it may be in the private business or private firm. Then conflict of interest may be actual conflict of interest where somebody is having this situation. This may be a potential conflict of interest, or it may be a perceived conflict of interest when people perceive that there is a conflict of interest. It may involve financial benefits, or even it may not involve financial benefits. Then you know that this conflict of interest may affect, or sometimes it is perceived to affect, impartiality of a person or even his job. Suppose someone is taking interview for selection of a candidate for some post, and his relative is also one of the applicant. Even if he is qualified, even if he is eligible, then perception will not be same, and then this perception may be of impartiality, which can erode confidence in that person or his job. Even he is fair, so it means that mere existence of a conflict does not imply wrongdoing, but then it is perceived so. So what to do? Conflict of interest has to be avoided. That is the key of success in such cases. And actually speaking, conflict of interest may be in almost every field where third party is involved. It may be teaching, it may be research, it may be legal profession, medical profession, recruitment, training, consultancy, works contracts, or any government or private organization. Suppose teaching is there and teachers' children are also studying in some class and they are very good in study and they get good marks, but then there may be a conflict of interest. Similarly, suppose a doctor is there and he is prescribing some medicines which are available in some chemist shop, then there may be conflict of interest, or he is prescribing or he is asking to get the lab test done, then also there is a conflict of interest. Similarly, in recruitment, as we have already discussed in brief, maybe in training also, if you are asking some particular trainer who is not considered a good trainer by the trainees, then there may be conflict of interest. Consultancy is part of not only procurement of works but also of many other fields, and it is one of the most important field which is to be seen that this does not have conflict of interest. In procurement works and consultancy, these two will be talking particularly in this talk, and as I discussed, there is maybe in government or non-government organizations. Then first is that there should be a policy regarding conflict of interest. So every organization has to come up with some policy, and the organization should prepare its policy where general guidelines may be there, SOPs may be there for employees, for committee members or some other members, like suppose some committee is formed for recruitment or for training or for taking some decision, or contract committee is there, or say building committee is there, or say appointment of consultants, or appointment trainers, whatever it is. So there should be a policy for conflict of interest, where these guidelines may be for employees separately, committee members separately, consultants separately, and so on. Then the policy has to be documented and intimated to all concerned. If it is with regard to employees, then they should know it. If it is with regard to some committee members, then they should also know it, so that decisions are taken accordingly by them. Then what happens, these general guidelines or SOPs help to decide conflict of interest, whether there is a conflict of interest as per the policy of the organization, or there is any potential conflict of interest, so that it can be disclosed by individual or by committee members. Then policy should be read by the employees and members, and they should understand the conflict of interest policy. In particularly, that should be mentioned in terms and conditions of the employees and engagement. Then these guidelines and SOPs should include the policy for actual conflict of interest. What will happen if there's an actual conflict of interest? Then for potential conflict of interest too, and then perceived conflict of interest, so that it can be disclosed by the parties and even to the parties concerned. The responsibilities of individuals should be defined in the organizations of the consultants, vendors, and suppose vigilance is a section is there, then the responsibilities of vigilance section in case conflict of interest is has come to the notice. Then they should acknowledge, declare, monitor, and take decisions in case of conflict of interest is noticed. Similarly, organizations and many organizations, what they do, they just find out or they have their guidelines or SOPs for gifts. Even in many government organizations, there is a cap, there is a limit beyond which the gift cannot be accepted by them. Value of gift is mentioned. So, but there may be this policy in many government or many non-government organizations or private organizations too. So, because we know that gift giving is a common way in business activities for making clients, particularly in private business, and this is favorable policy. So, this is though it is difficult to stop policy of giving and receiving gift, but organizations should be alert to form and to place the policy, and even cost or value of gift can be mentioned in the policy for the individual employees. And most companies or organizations declare that their policy or a maximum value for such gifts, as I have told for government organizations also. Then third party business deals can be reviewed, or they can be scrutinized by someone other than in charge of the deal, even though there may be no conflict of interest and no change may be required, and the concerned persons who are going to have the deal, they may continue. Their authority need not to be taken back during scrutiny, but then this helps to the organization. Then it is better that we discover the conflict of interest before we engage someone. Like suppose some consultant is required to be engaged, then it is better to find out whether there is maybe a conflict of interest, whether it is a lawyer or it is arbitrator or it is consultant for some particular work. So it is better to discover conflict of interest in advance rather than after appointment. So that would be better for the organizations in terms of time and money both, and in the interest of the organizations also. And then if you talk about connections of new clients or engagements having conflict of interest, so if a particular person or individual or committee members or committee is taking a new client, consultant, contractor or engaging any new engagement, it is better to know if they are involved in any ongoing case in which you have participated or your competitors have participated. So their past and conflict of interest must be known to your organization with your competitors. Then we can identify any personal relations between decision makers and clients and parties. Suppose we are engaged some consultant, expert or witness, arbitrator, contractor or vendor, etc. If the organization has the policy that if they are to declare the relations, if they have with any decision maker or any employee of the company or organization, they should disclose. These relations may be personal relations or financial relations which affect the conflict of interest, or even individuals. If they know, individual employees, they know that some consultant is being appointed, then they should also do so. So if organization suspects two people having a personal relationship, then that can affect the partiality of the case. Then organization may get the information and even take necessary action accordingly. And then every employee has to state their interest. They should disclose their interest conflicting to their job, business and organization, whether they are taking part-time job or engagement with some other organizations, members of the committees, joining political parties, attending functions, parties organized by business competitors, and so on. And most common is accepting hospitalities and expensive gifts, particularly with whom business is being carried out or likely to be carried out, to ensure that they do not have the conflict of interest with the organization. So suppose your competition is there with some firm, then employee is not supposed to accept the hospitality without intimation to the organization. Furthermore, the employees should inform potential investment. Suppose there is some competitor in whose company investment has been made by some employee who is making the decision, then there may be potential conflict of interest or even perceived conflict of interest. So this should be declared by the employee who is involved in taking decisions, because his decision might influence in the organization in favor of competitor. Many business organizations require employees to submit information related to conflict of interest once a year. Else they ask and they mention in the policy that they are to intimate whenever it comes to their knowledge right at the first time. So in brief, responsibility of individual is that he should disclose the conflict of interest, and disclosure is the remedy. Individual has the responsibility to identify and declare circumstances related to conflict of interest. Potential conflict should be disclosed to the parties that will be affected by the action or decision. Disclosure should be done as soon as possible. An outside party can help you put your interest in perspective to determine whether this is a conflict or not. So if you have doubt, then it can be done because it is easier for third person to identify it. Then employees are supposed to disclose personal relations or ties to the organization. Suppose you have financial investment with some other company, that should be disclosed. If you have connections to the government, political parties, that should be disclosed. Or you suppose your close relative is working in some your competitive firm, and then you should disclose it. And suppose your status has changed, then also you should disclose it. That is, you should inform to the organizations if this is as per the policy. However, no one expects to disclose every instance which might arise in future as a conflict. But if you have potential conflict, then it should be done. And then if there is a conflict of interest, you may still be able to proceed through informed consent. Maybe that your organizations give consent to go ahead, or he may not continue for you. He may ask you to withdraw from the committee or from the decision making process. As you might have seen that many times the judges even withdraw from the cases when if they have taken up the case earlier of the party, one of the party as a lawyer. Then without breaking confidentiality, employees should tell the client of the potential conflict. And if they understand the conflict and still agree to hire you, then they may sign a contract. Then there are different professions and they have different type of conflict of interest. It may not be similar in all the places, but if you see the definition, similarities in the objective. Knowing what you may encounter in your profession, that will prepare for you dealing with the situation when it arises. If you are, we have discussed that if you are having a side business or working with your competitor, it should not offer the same type of products or services, but still your employer will decide. As a consultant, you should not offer services to competitive businesses unless you have disclosed that to the companies. If you are the consultant and PMC, it may lead to conflict of interest in the case of work contract. Suppose you are project management consultant, you are carrying out project management also, and you are also the consultant for preparation of the drawings. Then this is a conflict of interest, because if you change the drawing, then the variations may be there during the execution of work. So during execution, you are the project manager and you are approving the variations. So this comes under the conflict of interest. Then you must consider potential conflicts also. It's not only actual conflicts. So if there is a slightest possibility that a conflict might arise, it should be disclosed. And even if you are not earning any money, then also. And suppose you are engaging a contractor for maintenance or work, and suppose your relative is a contractor, maybe family member, or suppose your wife is there, or suppose your uncle or somebody else is there, he is the director of the company, then you have conflict of interest. Then this may be considered as not only this will be perceived conflict, also if they are tendering in your organization, then it may lead to potential conflict of interest. So this has to be disclosed earlier. If we talk about conflict of interest in different organizations, suppose in research, then everywhere it is there. So because if individual have the preference or obligations over his duties and responsibilities, then it comes like this. Suppose somebody is sponsoring the project and you are working according to the sponsor shape, then it is not the actual research, then it becomes conflict of interest. Or suppose you are providing consultancy also for the company and you are doing the research also in that one, then also if they are funding, then also maybe, so it is to be disclosed. Or suppose you are reviewing the work or you are the reviewer of the research work, then also. Then conflict of interest is very common in legal profession also, and lawyers, judges, committee members, arbitrators, dispute resolution board members. So this is also to be seen, and you know that in Arbitration Act and Conciliation Act, now it has come that arbitrator has also to disclose and has to ensure that there is no conflict of interest. So arbitrators' present and past relations is seen with any party. Their relations is seen relationship to the dispute or in the dispute. Even financial investment in any party share, relations of arbitrator with the arbitrators of the tribunal, known conflict of interest in case or with any other party. So this is in arbitration case too. Then as we have discussed that types of conflicts can vary from profession to profession. There may be actual conflict of interest, potential conflict of interest, and also perceived conflict of interest. It may be conflict of duty, direct interest, indirect interest, financial interest, or non-financial interest too. Financial interest we have already discussed. This may be direct or indirect. Suppose your spouse or relative is working in the company, or they have the stocks or shares. As we have discussed, suppose you want to engage some contractor, maybe for the work, or maybe for the canteen, or maybe for some other thing, or vendor, and then you are engaging them, then this is a conflict of interest. Suppose you want to purchase materials and your relative is supplying it, then this is a conflict of interest. Then there may be personal relations. Suppose somebody is working and you are the contractor, and your relative, your say brother or husband or wife or close relative is working in the organization who can affect the decision who is suppose involved in tender preparation, and he change the conditions according to the benefits of the relative, then this is a conflict of interest. So during planning also there may be conflict of interest. There during execution of work, that there may be conflict of interest. During designing also, suppose structural designer is there and he is the relative of the contractor, then there may be conflict of interest. So in many cases conflict of interest will be coming in procurement of works. And then in teachers, professors we have discussed, because he may be the relative of a student, then favoritism can be there. And then during recruitment there may be personal relation. You may select to your relative or you may not select to your relative, but then it may be perceived as a conflict of interest if you select. During project management we have discussed, but even for bill auditing, suppose auditor or accountant, divisional accountant is your relative of the contractor, then there is a conflict of interest. So conflict of interest in procurement of works may be at consultant level, and that is serious if it is there, because consultant, if he is preparing tender documents, and then there can be favor to someone, or there may be weeding out of some eligible contractors. And then there may be stipulation of specific make or brands of material which are purchased from particular vendors where conflict of interest is there. Then if consultant is preparing the tender document, he is also doing the designing, architectural, structural and other designing of say HVAC or MEP services. And suppose he is also working as project management consultant or project manager, and he is accepting the work, then there will be conflict of interest. And suppose he is working as a contractor also, and he is also the consultant, say some company is there, or then there will be a conflict of interest. So in procurement of works, there are many chances of conflict of interest. So FIDIC has in fact identified conflict of interest in case of procurement of works, and for the consultants they are very particular, and they have a lot of guidelines, and they are concerned with this issue to avoid conflict of interest. Then European Federation of Engineering Consultancy Association is also concerned with the issue, and they are also they have a lot of restrictions on the consultants so that this conflict of interest is not there. Then also OECD, Organization for Economic Cooperation and Development, they are also dealing with this issue of conflict of interest, basically with the principles for managing ethics in public services. So they have also a mechanism similar to others, so that this is conflict of interest is avoided. Then World Bank also has highlighted this issue for consultancy services, for consulting service manual, in which conflict of interest has been included as chapter, both for the borrower and the consultants. Then basically a consultant conflict of interest we have already discussed, that it is a situation in which a consultant provides biased professional advice. It may be to a borrower or other person in order to obtain from that borrower other person an undue benefit. So that is to be done. That is to be avoided. And then in procurement of works, we know there are a large number of chances at every stage where conflict of interest may be there, like from preparation of architectural drawing, structural drawing, MEP drawings, stipulation of makes, particular makes, acceptance of particular makes or brands of materials. Then during execution also, particular brands, particular materials, approvals, delay in approvals, timely approvals, then during selection of contractors, during fixing eligibility criteria of contractors. So there are large number of stages where conflict of interest may come in during in the procurement of work. So that is very, very serious then. That's why in all the organizations it is seen seriously. And then FIDIC policy is there, as we have discussed. So large number of guidelines have been given in the FIDIC policy, so that conflict of interest is avoided. Relations with clients, staff, with vendors, so basically idea is that there should be prior disclosure. If there is a conflict of interest, there should be transparency and there should be independence. Transparency is the main criteria for during procurement of works. And then CVC has also come out with the circulars, Central Vigilance Commission, Government of India, Central Vigilance Commission of India, and they have come out for the circular very early in 2011, where they have guidelines for selection and employment of consultants, particularly to avoid, and they have mentioned how to avoid conflict of interest. So they have guidelines, so those are to be followed by every government organization. So thank you very much. I'm KM Soni, former ADG CBWD. Thanks a lot for patience hearing. Thank you.